pretty blunted in terms of his affect.
Why? I think you called it congruence. What do you mean by congruence?
It's really important when we're communicating with people that we are congruent. So what we're feeling is what we're showing to that person. If you're feeling something and not necessarily showing it, then people can kind of pick up that you're incongruent, something is going on with you, and it leads to lack of trust. So it's important. Congruence is important. It's also important because it makes somebody predictable, so that if you say something to me and I know that you are someone who what you say is exactly what you feel, then I can trust you and I can predict your behavior towards me. When people are not congruent, you can't necessarily predict their behavior towards you, because what they're saying and what they're actually feeling are two different things. So the congruence is a huge issue in relationships.
Why is that concerning for children in particular? That lack of congruence.
A lack of congruence in children, one of the things that an adult role is to teach children to be congruent, to teach children what you're feeling is what you need to be speaking, in a respectful way, but you need to speak your feelings. If they don't have that, then the child is an unpredictable child, because the child can parrot back to you what they know you want to hear, but they're not necessarily changing anything internally.
What is the treatment for an attachment disorder? What are the treatments?
There are treatments for attachment disorder. There are also some treatments for attachment disorder that are very, off the cuff and not good treatments, and nobody really, and professionals would recommend them. But the treatment right now for attachment disorder, most people would treat it as a trauma-based disorder, and they would do trauma-focused cognitive behavioral therapy or regular cognitive behavioral therapy. There's dialectical therapy. There's certain therapies that are known to work with children that have attachment issues.
Were any of those ever recommended to the Ferriters?
Objection as to hearsay.
Sustained.
Is it your opinion that the Ferriters were? Do you have an opinion as to whether the Ferriters acted with malice when it comes to the treatment of attachment disorder?
Yes.
Okay, what is that?
Laura, can you approach for a second? All right, so the court is reconsidering its prior ruling on the question of whether there were any recommended treatments. Ms. Murad, you can ask the witness that question with respect to her review of the records that she had presented to her in this matter. But, ma'am, just so you know, you're only able to answer that question with respect to the records you reviewed. You're not allowed to get into that with respect to anything else anybody else may have said to you, because that would be hearsay. But if there's something in the records that can form a basis for you to answer the question, I'll allow you to do that. Okay?
Thank you, Your Honor. Based on the records that you reviewed in coming to your various opinions in this case, is there any evidence that the Ferriters were recommended those treatments that you just mentioned?
No.
Is there any evidence in the records that you reviewed that they were recommended inpatient treatment for attachment disorder?
No.
Is there any evidence in the record that the Ferriters were recommended to go to a specialist for attachment disorders?
No.
And just so we're clear, Ms. Murad, you're talking about the records that she reviewed,
Yes.
not in the record in the global sense
Not
of
the-
this
the
proceeding.
records,
Yeah.
just the ones you have. Yes. All right. I want to go into, Your Honor, my next opinion does require me to approach. I'm wondering if it's a good time for a break.
Yeah, it is good, because we've been going about an hour and a half this morning. So we'll take a break, 15-minute break. It's almost 10:30. We'll be in recess until 10:45. All right, everyone may be seated. All right, you need to approach?
Could we just do it?
We can do it.
Here. So, Judge, my next opinion, the court has sort of made a preliminary ruling on this, but I wanted to readdress it before I asked Dr. Rappa. So, in the cross-examination, actually, I think it was in the direct or redirect examination of Wade Myers opined that when you remove a child from the environment that they're in that's causing issues with their attachment. So specifically, and we listened to this yesterday, so Wade Myers agreed that Ronan has probably an attachment disorder from his early childhood when he was adopted. He then said that it was, quote, brought back by the Ferriters. And he then said that if he is placed in a different situation or environment, or children with attachment issues are placed in a different situation or environment, you expect to see an improvement in their behavior. And so I believe, based on the records that Dr. Rappa has reviewed, that at the very least, the defense should be able to counter that position to show that that improvement has not in fact happened, because there is an issue here of the persistent reactive attachment disorder and how the Ferriters couldn't have really done anything to improve it. And it is direct rebuttal to what the state's own expert testified to. So I would like to get into that, and I'm sure the state will be objecting.
All right, so Ms. Coakley, make sure you use a mic and state what your position is.
Yeah, I mean, the state would object. I think that there is a fundamental difference between saying generally this is how it is addressed, which is what Dr. Rappa has already testified to, that generally how it's addressed is that it focuses on the parenting in a nurturing, safe parenting environment. There's a fundamental difference between that testimony and saying that that would have solved it in this case, which is not what his testimony was. He testified generally. Beyond that, it's much more complex and nuanced than the defense wants to make it seem. It's not an automatic solution. I don't think any psychiatrist or psychologist would say that, especially after 3 years of additional trauma perpetrated by the defendants, then to go into every single thing that has occurred to the child after.
So what is the legal basis of your objection? Is it foundation? Is it relevancy?
It's improper character evidence, Your Honor. And whether or not the child in this case was cured after being removed from the parents is not a relevant determination for the jury. That doesn't have any bearing on whether or not the defendants committed a criminal act in this case. Whether or
That
not
sounds like a relevancy objection to me as well.
Right. It's like nuance. So it's like the idea is first that it's improper character evidence that confuses the issues and is prejudicial because it gets into such a complicated issue. But so it's, Your Honor in limine said that is not permissible. It's improper character evidence.
And that's right, and that's why Ms. Murad said I'd already preliminarily ruled on it.
Right, but beyond that, it's not even relevant because, like, how easy or how hard it was to manage their child is not a defense to the criminal charge here. And so whether or not he was able to or continue to have behaviors after they were removed is not relevant to the determination of the defendant's intent or knowledge in this case, or whether or not they committed a criminal act of child abuse.
All right, final remarks on it, Ms. Murad. And I'll help you out with at least the concern I have is I think it's completely irrelevant whether the child gets well or not after he's removed from the home, because I agree with the state's position that whether the child gets better or not does not decide the issue of whether the treatment and the conduct of the parents in dealing with the child prior to the child's removal was appropriate or not to the circumstances. You've testified as to the circumstances that, or you've had your witness testify as to the circumstances that existed while the child was at home, and that was with the reactive attachment disorder. So that's appropriate, but now, and that's relevant because that's what they're dealing with in real time. It guides and determines their conduct, their response to a minor child having reactive attachment disorder. But what happens after the child's removed, I have a real difficult time connecting the dots because it's irrelevant to the parent's conduct that they pursued while the child was with them and while they were dealing with the issue. So that's my major concern, is it's just not relevant. And why should I change my pretrial ruling already made in this case that I wasn't going to allow this area of an opinion and conduct to be looked at?
So the reason I think the court should reconsider its ruling is because the state has made it relevant. Everything that the court is saying in the state's sort of argument in the second half of their argument is the same thing that we litigated in motions in limine. We are now in a different posture. The state could have instructed their expert, do not say anything that could create an issue with what's happened after the fact. We all do that with motion in limines, and we instruct our witnesses, don't testify like this, don't bring this up. Now it has become relevant. So the reason it's not improper character evidence, as the court knows, is only inadmissible to the extent that it goes to show propensity. That's not what we're doing here. They have had an expert, a doctor, testify that when you remove a child from that situation, they will get better. And he may have said that generally, but we're in a case here about Ronan's behavior and whether or not the Ferriters are guilty or not guilty. Now, I understand the state's position as to, these are perpetrated by the Ferriters. Their version of the theory of their case is not, I do not have to abide by that. I certainly understand that there are relevance objections and everything, but their version of their case they can present. I don't have to present that version.
Okay. I recall well the underpinnings of my ruling pre-trial on this, and I can tell you that my ruling was informed by much more than just a relevancy consideration, but it was also informed by significant case law that had been presented to me regarding the privacy interest of the victim in this case. And it was because of that and a substantial amount of authority that weighed in heavy favor of not allowing this type of information to be pursued with a victim in general, but a child victim in particular. So I'm going to sustain the state's objection, maintain my pretrial ruling and my order in limine on this. So with that, I'm going to give, do you need anything else? I'm going to give you a break until for you to continue.
Can I just proffer the questions?
You can proffer the question. That'll be fine. Go ahead, Ms. Murad.
Thank you. Wade Myers opined that when you remove a child from an abusive environment, you expect to see improvement in their behavior. In general, do you agree with that? We're just proffering, so you have to answer it. When would you not agree? Are there circumstances where that's not the case?
Sure. If the child has real significant psychiatric problems, then we're not going to necessarily see it remit just because they're put in a different placement.
In this particular case, is there evidence that Ronan has in fact improved since his removal from the Ferriter home?
I'm just going to object because
This is proffer.
I know it's proper, but we're in open court here. This information was protected pursuant to multiple privileges, and so now to put it on a televised.
I think that's a fair objection. Let me have both sides approach. Thank you, Ms.
And then when is our break until, Judge? I'm sorry. 45.
All right, so the court is going to sustain the objection. It's without prejudice to the defense to do a written proffer with a confidential filing, because the court has found previously that the minor victim's treatment post removal from the home is protected information, and it would violate his privacy interest to have that disclosed publicly. So I'm maintaining that ruling, maintaining that protection that I originally ordered. However, I also acknowledge the defense's right to put on a proffer of what evidence it would have submitted, but for my ruling, and I will allow that to be done in a way that it is not public at this point. You can do a sealed proffer for filing that will become part of the record going forward. Ms. Murad, anything else before we've chewed up the break, but I'm going to still give you 5 or 10 minutes. Anything from state? All right, so we're going to take a brief recess. Ma'am, you can step down, stretch your legs, but during the break, you're not to discuss your testimony with anyone. You understand all that? All right. Thank you. Court will be in recess for another 10 minutes. All right, everyone may be seated. Ms. Murad, you ready to continue?
I am, Your Honor. Thank you.
All right, Mark, you may bring the jurors back out.
Yes, sir.
Ms. Murad, I'm going to, instead of doing a written proffer, we're going to do a sidebar, and we'll do the proffer at sidebar when this witness is done.
Sure, no problem. Whatever the court prefers.
All rise.
Jury in.
All right, everyone may be seated. Ms. Murad, you may continue.
Thank you, Your Honor. Dr. Rappa, we talked about reactive attachment disorder. I now want to turn to something else that you mentioned during the course of your direct examination. Do you have an opinion as to whether Ronan has symptoms indicative of oppositional defiant disorder?
Yes.
What is that?
Approach. All right, the objection is sustained. You may continue, Ms. Murad.
Do you have any opinion as to whether Ronan has PTSD?
Yes.
What's your opinion?
I do believe he has signs and symptoms consistent with complex post-traumatic stress disorder.
What is complex? Well, let me start with this. What is your opinion as to when that complex PTSD started?
I believe that it started when he was an infant, when he was a very, very small child, up until the time he was around almost 2.
Explain that to us. How are you able to make that determination?
Well, post-traumatic stress disorder in infants is something that has recently been looked at. People thought, oh no, they're newborns or they're young children, they don't remember anything, and nothing in their environment really impacts them, so it doesn't matter. Nothing really can be further from the truth when you start to look at it, and when it is studied. So children that have had adverse childhood experiences, whether it's trauma or severe neglect or medical neglect, anything like that, can cause signs and symptoms of post-traumatic stress disorder in infancy.
So when you're determining whether or not a child has complex PTSD that's rooted in issues from infancy, are you relying on the DSM-5?
No, normally what you're going to rely on when you're diagnosing a young child is called a diagnostic classification 0 to 3. So it looks at young children, and then it looks at what behaviors young children might exhibit, as opposed to the DSM, which does talk about children with PTSD, but really doesn't deal with early life experiences.
Is it your opinion that the Ferriters caused the complex PTSD that Ronan has?
No, I mean, I think that it's a complicated mix of reactive attachment disorder and complex PTSD due to everything that he went through from birth until like 17 months of age.
And without discussing the substance of the records or any hearsay, is there evidence prior to about May of 2018 in the record that supports that Ronan has symptoms indicative of complex PTSD and reactive attachment disorder?
Yes, and sometimes these disorders mirror each other. So when you have young children, they really can't communicate. So the way that they're communicating is through their behaviors. Therefore, if you see some children, that's why you'll see lots of times when you're looking at records of young children, you'll see that different providers are giving them different diagnoses because some of them are similar or they mirror each other. Because again, children can't tell you what's going on with them. You have to see it through their behaviors and what the parent is experiencing at home.
We discussed earlier on, I guess I'll call it part one of this direct examination, about congruence and trust. Could you remind us about that, about the role of trust in human relationships?
Sustained.
So without reminding us about what you said, how is trust involved in the parent-child relationship?
Throughout you raising your children, trust is involved. You're teaching your children that you have to be able to trust them, and as they get a little bit older, you're giving them a little more independence. You're watching to see how they handle it. If they start to handle it badly, then you take away a little bit of independence, and so that trust between you and the child grows in that way. If you have a teenager and you let them use your car and they stay out too late, you take the car. I mean, that's good parenting. That's just parents that are teaching children, hey, I'm gonna let you get a little independent, but if you show that I can't trust you, I'm gonna pull back. And that's exactly how parents raise children that then learn to be responsible and accountable.
What behaviors are associated with a lack of trust, or someone that, perhaps someone would not feel comfortable trusting?
Objection, relevant, speculation.
Sustained.
What evidence in the records have you reviewed that, well, let me ask it this way. Do you believe that a lack of trust, and I'm talking about this in terms of like psychology, your field, is there evidence in the record of Ronan doing activities that are not trustworthy?
Yes.
Object, improper opinion.
I didn't catch the last part of that question. That are not what?
Trustworthy, just because we're using that language in the psychological sense, Judge.
So is this a psychological opinion you're asking, or just her?
Psychological opinion, Judge.
And what's the basis of the objection? Sustained. Commenting on the credibility.
Not commenting, so let me start with this. What are behaviors that indicate that's a lack of trust?
I'm going to object as to relevance.
Sustained.
If you have someone who is doing things like stealing or lying, are those behaviors that show that, they're tied to like manipulation or dishonesty? Is that fair to say?
Objection, improper opinion, improper character evidence.
Sustained.
Can you
Let me have you approach. All right, the objection sustained. You may rephrase, Ms. Moran.
Does trust affect how a parent responds to a child?
Yes.
Explain that to us, please.
Yes, so as a child proves themselves to be more trustworthy and doing things that are, they're accountable and they're responsible, then the parent learns to trust that child, gives them more independence, and, the child moves on into adulthood.
In your review of the records in this case, is there indication that the Ferriters responded to that lack of trust from Ronan?
Objection, speculation.
Overall, you have to answer that with reference to what you actually viewed as far as the records that drive your opinion or answer.
Go ahead.
So will you ask it one more time?
Sure. Is there evidence in the record that that sort of the parent's response to that lack of trust happened in this case?
Yes.
Okay. Without discussing the specific information in the record, explain to us how you've come to that conclusion. I know that that's hard.
It's hard. So there would be behaviors by Ronan, whether it was at school or at home, and those behaviors would elicit a consequence.
Is there, how do parents, again, I'm talking about in psychology, when a parent sees sort of a lack of trust, how does that parent respond?
Normally, what you will see is a parent that tries to gain control of that child. So the more the child seems out of control, or the more the child seems untrustworthy, the more the parent then tries to put control on them, put external control around, or keep them somehow, safe, or whatever the parent is going through at that time. So I think the parent's initial reaction is to clamp down and be more controlling of a child that they feel like is out of control.
Is that a normal or natural response by a parent in that type of situation?
Yes, in my experience working with parents, that's the first thing they try to do, is to see if they can't gain some control over a situation they feel is out of control.
I now want to get into another opinion of yours. So you did, in fact, review the trial testimony and the deposition of Dr. Wade Myers, correct?
Yes.
And Dr. Wade Myers testified that the Ferriters engaged in malicious punishment. Is that correct?
Yes.
Do you have an opinion as to whether or not the Ferriters did, in fact, engage in malicious punishment?
Yes.
What is that opinion?
I don't believe that they were malicious insofar as they were deliberately trying to abuse and hurt their child. I think that they were responding to behaviors that they were very concerned about, and they were trying, it's almost like they went into a let's contain and monitor and make sure that nothing's going to happen. Did they do something appropriate? No. Did they handle it appropriately? No. But I don't think it was just an arbitrary, I'm going to abuse this child, be cruel to this child, for no reason. I think in their mind, they were trying to contain some behaviors and keep everybody safe in the process.
There are records that indicate that the Ferriters went from sort of provider to provider, perhaps not staying with one for a very extended period of time. Do you have an opinion about that?
Sure, I see that happen all the time. Unfortunately, I wish I could say that all mental health professionals are excellent at what they do, but that's not necessarily the case. And sometimes you go to a provider that, what they're dealing with is a little over their head, or what they're not trained in evidence-based treatment, so they're trying to do talk therapy with a 7-year-old, which doesn't work. And lots of times I think that even us as clinicians, we kind of sit back in our world of theory, and this is how things are supposed to be theoretically, and this is how you make a perfect family, and this is how you do it. And so you just tell your child, you need to talk about your feelings, and every time the child is out of control, you sit down and calm them and say, talk this out with me. That's theory, and it's beautiful parenting, but it doesn't always work when the gravel hits the road. So lots of times parents will, in my experience, get frustrated at mental health providers because mental health providers try to make it sound like it's just so easy to do. but they're not the ones that go home with a child that's tantruming for an hour or an hour and a half, and they don't know how to soothe them.
We've talked about a couple potential diagnoses for Ronan. Is the actual specific diagnosis really does that determine whether or not you believe that there was malicious punishment? Like the specific diagnosis that Ronan may or may not have?
No, I mean, I don't think the specific diagnosis. I think in terms of maliciousness, maliciousness for me would mean that somebody would be arbitrarily abusing somebody with the purpose of making things worse for them. I think that when we see the behaviors that were being displayed and some of the behaviors that were happening, that they weren't necessarily being malicious. They were trying to contain and control it in a very inappropriate way.
Do you have an opinion as to whether, based on the records that you reviewed, Ronan was a danger to himself and others?
You can approach. We're going to take a 5-minute break. Council needs to review something before we proceed further. All right, go ahead and have the jury retire to the jury room. All right, and it's going to be 5 minutes sharp, Ms. Murad. If you don't have what you intend to present to the court, we're moving on. was disclosed, I'll look at it. Yes, go ahead.
So, Judge, Dr. Rappa was deposed twice, once on September 20th by the state, a second time on September 27th by the state. The state asked on the bottom of page 11 of the first deposition, I want to just kind of start with what opinion you expect to give in this case. It gets very lengthy, but she states several opinions that she would give. This includes, as he kind of got older and his behaviors got what they thought were more dangerous or more intense in terms of feeling or in terms of hurting other people or hurting themselves, that they, started thinking that we need to manage these behaviors, and the behaviors are so out of control, how can we manage them? And of course, the way they chose to manage them was probably the worst way anyone ever could. Then she said, what else? And that was on page 12. Page 13, lines 7 through 15, where Dr. Rappa describes sort of at length what her opinion is, and then the state goes specifically. In the second deposition that the state took, I had asked Dr. Rappa whether or not in a clinical setting she makes determinations about whether or not a child is a danger to themselves or others. Ms. Coakley specifically, and that was on the second deposition taken on September 27th of 2023 by the state, page 35, lines 7 through 15. The state also asked Dr. Rappa, this was regarding something different that was said in the CPT interview about whether or not is it appropriate to, as a child is using the restroom, sort of have the door open, as there were allegations of that in the CPT interview. And Dr. Rappa said that where there is a danger, that is something that happens in a clinical setting, and that is on page 19 of the September 27th deposition. It's sort of at the end of page 18 all the way to page 19, ending at line 5. As to the oppositional defiant disorder, that is on the September 20th, 2023 deposition, page 38, line 8. Let me just get there. This is the state's questioning of Dr. Rappa. It starts on page 37. I think on page 38, the relevant line numbers would be starting at line 2. Ms. Coakley says, and there's also several other disorders that can share symptoms or overlap or share features, right? Dr. Rappa says, yes. Conduct disorders can. I see you nodding. You just have to say yes. Dr. Rappa responds, yes. The state then asks oppositional defiance disorder, and Dr. Rappa says, yes. And then she lists several other anxiety disorder, social phobias. She lists several other things. So I think in addition to the depositions in the records that the state was provided, Ronan has been diagnosed with oppositional defiant disorder and reactive attachment disorder.
Ms. Murad, in any of those, because what you just read doesn't even get close, in my view, of being an opinion being rendered by this witness as to whether she had, based on her review of the records, reached an opinion as to whether ODD was applicable, or based on her review of the records, she had reached an opinion that the child victim was a danger to himself. Just mentioning ODD or being a threat to someone's self is not the same as an expert providing an opinion as to whether that is in fact her conclusion. Do you have anything that indicates that that was her conclusion that she was drawing, that the child victim in this case was suffering from ODD or was a danger to himself, as to which the parents had to respond?
I don't have anything additional to what I've already cited on the record, Your Honor. However, I will say that the idea that the state was not on notice or able to explore this in their own deposition, just as we were in our deposition of Wade Myers, I think is not fair.
All right, well, whether it's fair or not, I'm not going to comment, but both sides know that trial is not the time for dropping new opinions with an expert witness, and I'm not going to permit it in this instance, so I'm going to stay with my original ruling that the questions concerning this witness's opinion on ODD or that the child victim was a potential threat to himself have not been properly disclosed, and therefore they're not going to be permitted to be introduced in this trial. Ms. Murad, anything else you wish to make for the record before I bring the jurors back out? All right, thank you. Mark, you may go ahead and bring the jurors out. And Ms. Murad, you may continue with your direct. All rise.
Jury entering.
All right, everyone may be seated. Thank you. You may continue, Ms. Murad.
Thank you, Your Honor. When we talk about reactive attachment disorder and complex PTSD, are there behaviors associated with those diagnoses that can become harmful or dangerous to people, to the child or the people around them?
Yes.
Are those behaviors exhibited in this case?
Yes.
Take us through how you've come to that opinion.
Okay, so we know that as early as 2015, some of the symptoms that are being documented for the child include things that are emotional lability, like the temper tantrum, sleep issues, anger and frustration, anxiety and fears. This is, kind of how we pinpoint PTSD in a child, especially in a very young child, because, again, they can't really tell us what's going on. There were also indications in the records where there would be inappropriate behaviors that were hurtful toward other people, and maybe not, maliciously done by the child necessarily when he was young, but so impulsive that, if the thought crossed his mind, he would go ahead and just do whatever it was that he thought about, and it would result in somebody getting injured. There were also, records that suggested that he was doing things that were dangerous in the home, and dangerous to other people that lived in the home. So, and that's not an uncommon thing when you see children with reactive attachment disorder, because those children really do have very active minds, and while they can be very impulsive when they are emotional, they also can be kind of calculated. They can figure out something that they want to do or take apart, or how they can steal something, or how they can pull something over on an adult, and then they're able to do that. So you get kind of both of that with a reactive attachment disorder child in it, and these things make them dangerous to themselves many times without them even realizing it, and dangerous to others.
Is there evidence in the record that prior to 2018 there were issues with Ronan roaming around the house at night?
I'm going to object
Sustained.
Did you rely on records that indicated sort of wandering or eating at night?
Objection, hearsay.
Sustained.
Based on the records that you reviewed, sort of what, do you have any opinions as to why? So you mentioned that Ronan's behaviors didn't have predictability. Is that fair to say?
Didn't have what, I'm sorry?
Predictability.
Correct.
Why is that concerning for a parent?
When you have behaviors that aren't predictable and the child is trying to kind of outsmart you or get one over on you, you're not quite sure what's coming next. So sometimes what's coming next is something that can be pretty dangerous.
Objection, speculation.
Sustained.
I move to strike, Your Honor.
Answer, the last part of the answer is stricken. Jury is instructed to disregard it.
Is there evidence in the record, as you just stated, that Ronan was exhibiting dangerous behaviors?
I'm going to object.
Sustained.
I want to talk about a particular. Ronan admitted in his trial testimony that you've reviewed in coming to your opinions, correct?
Yes.
That there was a search that he made on his school laptop for something very violent. Are you aware of what the substance of that search was?
Yes.
What was it?
I'm going to object as to hearsay.
Sustained.
What is, can you explain to us how the searches that people make, like why is that relevant in determining anything about someone's, whether or not that person is a danger?
When you're looking at
Approach. All right, objection sustained. Ms. Murad, you may continue.
Is it your opinion that the Ferriters were responding to Ronan's behavior?
Objection, speculation. Also asked and answered.
I'm going to overrule in part, sustained in part. You can answer it, but it has to be solely with reference to what you observed and reviewed in the records that you reviewed in connection with your opinions as an expert in this matter.
You ask again?
Sure. Is it your opinion that the Ferriters were responding to Ronan's behavior?
Yes.
And is that behavior indicative of early childhood trauma?
Yes.
Do we see Ronan's behaviors or the ones that the Ferriters are responding to prior to May of 2018?
Objection.
Sustained.
Did you rely on records in coming to your opinion before 2018?
Yes.
No further questions.
All right, cross, Ms. Copeland.
Good morning.
So you were hired by the defense in this case.
Yes.
And you charged them a fee. What was your fee in this case?
I charge $350 an hour. As of today, I have made $5,000.
And then there'll be an additional amount for testimony today.
That is correct.
Preparation for this type of thing, correct?
Yes.
Now, today, your work is mostly in the courts.
Correct. 100%.
Right. And mostly criminal cases, correct?
Not necessarily. I do a lot of civil cases also.
But as a court psychologist or a forensic psychologist, that means that you do things like competency evaluations for the court?
No, ma'am, I don't do very many competency evaluations. I'm not on the wheel or get appointed by the court for that. Occasionally, I might do one for a criminal attorney, but it's very rare.
You do insanity evaluations sometimes?
Yes.
Whether or not someone was sane at the time of the trial?
Yes,
You do risk assessments for sex offenders?
I do.
You do assessments for criminal defendants in general to make a determination for things like sentencing,
Yes,
to
I do.
advise the court. You haven't been involved in any publications related to childhood trauma, attachment disorders, or bizarre punishment, correct?
I have not.
And you don't do peer review for that type of stuff for scholarly journals.
I do not.
And while over the course of your career you have treated patients, you don't treat reactive attachment disorder.
I don't. I treat early childhood trauma. I have no issue with that. But once it gets into persistent reactive attachment disorder, no, I would refer that out.
You would send it to another professional in the field.
I would.
And while you have testified as an expert in court on a lot of different topics, a lot of different psychological issues, you've never testified in court before on a case involving extreme, bizarre, or malicious punishment, correct?
Yes, I believe that's true.
So this is the first one.
Yes.
Now, I want to talk about the items that you reviewed in this case. You did not speak to the defendants, correct?
That's correct.
And so your assertions about what they intended or what they thought or what they were trying to do, that's not based on any direct information that you have, correct?
That's right.
You don't actually know for sure what they were acting on or what their intentions were, correct?
No, I have not spoken to them, so I would not know their intent.
And you didn't actually speak to anyone in the case. You reviewed the records similar to Dr. Myers.
Yes.
And when I say that you reviewed the records, there's records from some prior practitioners. You didn't speak to them either, correct?
I did not.
Now, I want to talk about your opinion. You can't give a diagnosis in this case, correct?
I would feel very uncomfortable giving a diagnosis without interviewing someone.
Okay. And so part of that is that you have insufficient information to make a definitive diagnosis, correct?
Right, because I'm missing that interview portion.
But you do have an opinion on whether or not the defendant's actions were an appropriate way to manage the behaviors in this case, correct?
Yes.
It is your opinion that the way that they chose to manage the behaviors is probably the worst way anyone could ever manage these type of behaviors, correct?
That's correct.
Now, although you can't make a diagnosis, you think that there are indications that the child in this case has complex PTSD as well as an attachment disorder, right?
Yes.
And if a child does have an attachment disorder or complex PTSD, the way the defendant acted towards the victim is the complete opposite of what anyone should have done with a child with one of those conditions, correct?
Yes, ma'am.
In fact, confining and isolating a child can exacerbate those disorders, correct?
That's right.
And so exacerbate means make those symptoms worse,
Yes.
correct? Even in a child that doesn't have PTSD or an attachment disorder, this type of treatment of any child creates a risk of harm to that child, correct?
I agree.
To both the mental and physical health of a child, correct?
Yes.
So there is a reasonable likelihood that of psychological harm to a child that is treated this way, even if that child does not have any underlying issues.
I agree.
Isolation is not something that is used for children, correct?
It should not be. People
Right.
do, but it should not be.
Right. It's not recommended.
That's correct.
It's not considered acceptable within the psychological, within the child abuse community, really within normal community, correct?
Yes.
Now, I want to talk about some of the records specifically that you reviewed. You reviewed some emails from Immaculate Heart, correct?
I did.
That is where the child in this case went to elementary school, correct?
Yes.
So he's in 4th, 5th grade when he's at Immaculate Heart, correct?
Yes.
And if we do the math, that means he's about 10 and 11 years old during that time frame, correct?
That would be right.
So you reviewed an email from February 13th, 2018, which was one of the things that the parents got notified of, a behavioral problem by their son, correct?
I'm not, without having it in front of me.
Sure,
I'm
I
not
can get
sure,
it if you
yes,
look.
I
But there
did
was,
look at
one of
it.
those emails was about because he was using a bad word, correct?
That's correct.
That's one of the things that they got contacted about, correct?
Yes, he used the F word.
Right, and he said that using bad words makes him feel bigger, that he can be protected from the bigger kids if
Yes.
he uses bad words, correct?
He did.
He's 10 years old at that time, correct?
That's right.
On February 28, 2018, he punched a kid, correct?
Yes.
And that was in response to getting kicked, correct? That's the information.
That's what he said, yes.
That was the information provided to the parents, correct? 10 years old still at that time, correct?
Yes.
On May 15, 2018, we had that incident where he pushes another child against the wall with his fingers on the child's throat, correct?
Yes.
And the teacher concluded in that case that both children were not saying nice things to each other in that incident, correct? That kind of proceeded.
That's what she wrote, yes.
Right. And at that point, the child in this case was 10 years old also, right?
Yes.
There's October 29, 2018. That email is about roughhousing during a game. That's how the teacher put it, that he was roughhousing, right?
Yes.
December 3rd, 2018, they also got contacted, and it's because he stole a piece of candy off his teacher's desk.
Yes.
January 29th, 2019, he kicked a ball at a student, correct?
Yes.
And he got punished by the school by sitting out of recess and writing a letter of apology.
Yes.
And February 2019, they also got contact because he stole a container of sprinkles.
Correct.
He's 11 years old when he stole the sprinkles from school.
I would say so, yes.
February 2019,
Yes.
10 or 11. February 2019 is when there was a mutual physical altercation with another student,
Yes.
where they get into a fist fight, the little boys, and they're both punished. They both get detention.
Yes.
And March 8th of 2019, that's when there the technology issue, and he was found with a calculator, right?
Yes, he had stolen a calculator, correct.
And then March 22nd, 2019, he embarrasses his sister in class, correct?
Yes.
And that's about a month after his brother is born,
Yes.
when we know, based on the timeline, that he's already living in the garage that they built for him in Arizona, correct?
Yes, he would be by then.
A 5th grader, 11 years old.
Correct.
And then March 27, 2019, he uses inappropriate language again. He says another bad word.
Yes.
So between 2018 and 2019, at the elementary school, there's 2 incidents that involve physical contact with another child. The fighting incident and the push against the wall.
Yes.
For the large part, every other behavioral incident was something like saying a bad word or stealing a piece of candy or stealing another item.
Yes, that's correct. It's stealing or the candy, and then the humiliation of his sister, which I think was on a whole different level.
He got up in front of the class and he made her cry in class.
I mean, I think that if you look at it that way, it looks, kind of simple. He got up in front of the class and made fun of his sister or said some things, but
that,
really,
that's what occurred, right? My question is, that's actually the action that occurred, right? He's in the 5th grade, 11 years old, and he says something mean in front of the class about his sister, correct?
that is what happened.
Okay. Now, I want to talk for a second about that neuropsychological exam that we discussed. And that neuropsychological exam happened in October of 2022.
Yes.
So on the timeline, this occurred after the defendants were arrested and were charged with child abuse, correct?
That's right.
They did not have any of that information about the neuropsychological exam prior, correct? As far as you know.
Yes, correct.
And there's no indication from the records you reviewed that the defendants ever sought a neuropsychological evaluation prior to being arrested for child abuse, correct?
That's right.
And there is background information, I think you talked about it with the defense, that is self-reported, correct?
Yes.
That means that there is information that the child provided, and then there's also information that Ms. Ferriter provided, correct?
Yes.
And because of that, the report includes a limiting instruction or a cautionary instruction, correct?
Yes, all reports would.
And that information was provided after Tracy Ferriter had already been charged and arrested with the abuse of her child, correct? And the report itself contains the caveat that because it in part relies on self-reported information, it is limited in extent, correct?
Yes.
That it's highly subjective.
Yes.
Correct? And it may contain errors of interpretation, correct?
Yes.
And also omissions.
Yes, people are giving you their own perspective of the situation.
And you talked about those neuropsychological results, and there was, in part, some difficulties in executive function and impulse control, correct? Right? That was 2 of the things that report found, correct?
Yes.
And both of those things can be the result of trauma, correct?
Yes.
And ongoing abuse throughout a child's childhood could make issues with executive functioning worse.
Absolutely.
It also could make, if there's ongoing abuse throughout childhood, it could make issues with impulse control worse, correct?
Yes.
Anytime you take a child who has an early childhood abuse or neglect, and then you add to that, it's going to exacerbate any symptoms that they have, correct?
Yes.
So if you take a child that has early childhood neglect or an adverse childhood experience, right, like Ronan in the orphanage, that would be an example of an adverse childhood experience, typically, correct? If you take a child like that and then you subject them to additional ongoing abuse, that might exacerbate their symptoms, correct?
For sure.
Now, the report that we're talking about also talked about that the victim in this case had some difficulties in executive functioning, correct?
Yes.
And the way in which he was treated has the risk of increasing those difficulties, correct?
Yes.
He also had, you called it some difficulties in self-monitoring. The way that he was treated would increase the difficulties in self-monitoring, correct?
Sure.
You also mentioned that it was determined that there's some difficulties with emotional regulation, correct?
Yes.
The way that he was treated would increase his difficulties with emotional regulation, correct?
Yes.
Now, a child that has these characteristics that you said that were clinically significant, it is never an appropriate treatment for those types of clinically significant difficulties, the way he was treated, to confine him.
Yes, you're right.
You also noted that there was some difficulties in impulse control, but confinement is never an appropriate treatment for those difficulties either, is it?
That's correct.
And this report that occurred in 2022, it actually didn't come to the conclusion that he had reactive attachment disorder.
No, I believe he gave him an impulse control disorder.
And these types of difficulties that you talked about, difficulties in impulse control and executive functioning, they're not actually part of the diagnostic criteria for a reactive attachment disorder.
That's right.
Right? Individuals who do not have reactive attachment disorder can get these same results.
Sure. I mean, if they have a disorder of impulse, they can get it just because of that.
And these are areas of the brain that you also see impacted by someone who has PTSD.
Yes.
Now, want to talk about additional thing you reviewed. You said one of the things that you reviewed was the deposition. And I think it noted that the deposition was 5 hours long.
Yes, it was long.
That's a long time for any person, never mind a child, correct?
Yes.
And it's sometimes people, when discussing things, even traumatic things, respond in a way that is not necessarily considered normative or appropriate, correct? Sometimes people laugh inappropriately.
Sure.
Now, I want to talk about reactive attachment disorder more specifically. So, reactive attachment disorder is a diagnosis that's in the diagnostic. Tell me what it's called, the DSM. What does it stand for?
DSM-5, the Diagnostic and Statistical Manual.
And so that is the manual that psychiatrists and psychologists use that sets out the standard diagnostic criteria for a lot of psychological and psychiatric conditions.
That's true.
Also has some behavior disorders, some personality disorders, lots of different things. But it's a standardized way in which we evaluate if someone meets those criteria, correct?
That's right.
And you couldn't formally make the diagnosis in this case of reactive attachment disorder.
I did not, no.
But your opinion that there is some reactive or there's some attachment disorder characteristics here is based on the review of records of other people, correct?
Yes.
You don't know the methodology that any of the other people who looked at him relied upon, correct?
Yes, I don't know specifically. I know if they're licensed, then they would have to abide by, whatever their professional license is and the DSM to make a diagnosis.
But the reports that we have don't go into the underpinnings of their diagnosis, correct?
No, you wouldn't necessarily get that from anyone exactly how they got to their diagnosis, but you would assume if they're licensed that they have taken tests and been educated and supervised and know how to diagnose appropriately.
One of those people that made a diagnosis is a Mr. Kenny Miller, correct?
That's correct.
He is actually a licensed clinical social worker, correct?
Yes, he is.
So that's a master's level practitioner, right?
Yes, he is.
Not someone who has a doctorate like yourself or Dr. Myers.
Correct, but I will say that some of the best clinicians I've ever met in my life are licensed clinical social workers. So just because they have a master's degree as opposed to a doctorate doesn't necessarily make them a lesser clinician.
You actually, though, don't have any of Mr. Miller's clinical notes, correct?
I do not. Only what I was given, which I believe was a letter talking about when he had talked to the Ferriters and when he had seen them.
Okay, so you don't have any of the treatment progress notes that were contemporaneous to when he was treating in this case, correct?
Yes, I do not.
The only thing you have is a letter that he wrote after the defendants were arrested, correct?
Yes.
And the letter doesn't explain the diagnostic criteria, correct?
Not at all.
It doesn't indicate if he even met with the child. It's kind of vague as to whether or not he did.
I think he said he met with the child.
Right, but it's unclear once, twice, beyond that.
Right, that was hard to determine how many times he had met with the child, how many times he'd met with the parents. But he did say they had ongoing communication.
And if he did, in fact, meet with them, the time frame that we're talking about is after the child, the victim in this case, was 10 years old, correct?
That would be right.
And you're familiar with the DSM and the criteria that they have for reactive attachment disorder, correct?
Yes.
That manual also provides some cautionary instructions that practitioners should take into consideration when reaching a diagnosis, correct?
That's true.
And some of those cautionary instructions as it applies to reactive attachment disorder is that it shouldn't be diagnosed after the age of 5. Or if it's done, it should be done with extreme caution.
I agree
Correct?
with that.
That's what the DSM says.
Yes.
And based on the very limited information we have from Mr. Miller, we don't know why he is making that diagnosis after 5 years old, correct?
Right, I'm not sure why. I'm assuming that he would make a diagnosis the way anybody that is licensed would make a diagnosis.
And then you also review the records of a Dr. Reichenbacher.
Yes.
If I'm saying that correctly. And Mr. Reichenbacher is a psychiatrist.
Correct.
And he, you have some of his treatment notes from his meetings with the family and the child, correct?
Yes,
He notes reactive attachment disorder and ADHD, correct?
he does.
But he has no indication of the appropriateness of whether or not why he's making that diagnosis after 5 years old, correct?
Right, I don't think that you would normally see in somebody's treatment summary how they arrived at that diagnosis. You would see the diagnosis that they rendered, and you would assume that it was because they had records available or interview available, however they made the diagnosis. But we would assume if somebody is licensed that they're giving a diagnosis based on their professionalism and their knowledge.
And so you're making some assumptions about what they're relying upon because we don't have any additional information, correct?
Right, but there are standards and rules of how we diagnose somebody. So it would be very rare indeed for somebody to be diagnosing out of the blue with no information whatsoever.
Now, in looking at Dr. Reichenbacher's notes, there's no indication of whether or not in making his diagnosis that he was aware that during this time frame, the victim is being confined in a structure that his parents built in the garage, correct?
Right, that is not in his notes.
There's no indication that he was aware of that, correct?
Correct.
And that would be important information for a psychiatrist to have in making a differential diagnosis.
I think so. I would have liked to have that information.
Now, Dr. Reichenbacher saw Ronan between December 2018 and January 2019, correct?
Yes.
And so the last time we have of him being involved in all was January of 2019, correct?
Yes.
Which is 2 years prior to the arrest in this case?
Yes.
Now, there's a handful of meetings, 3-4 meetings total, correct?
That's right.
And the meetings, aside from the initial assessment, are about 20 minutes long.
Yes.
And the victim in this case is 11 years old at the time.
Yes.
And so in December 2018, they have their initial evaluation, correct?
Yes.
And the recommendation is that perhaps the victim in this case may need behavioral therapy.
Correct.
And then in May 7th of 2019 is the next meeting,
Yes.
correct? And it's noted from the report that the parents reported to their psychiatrist that they are seeing for the behavioral problems of their child that he is not having severe aggressive behavior at school. That's what the parents report, correct?
Yes.
And they also noted adequate behavior at school regarding focus and hyperactive behavior, correct?
Yes, he had been placed on medication at that time.
And then the doctor decided at that point that the treatment going forward would be to continue medication and therapy, correct?
Yes.
But there was a problem because the parents were going to go away for the summer, so he might not be able to get that therapy.
I don't remember why they didn't, but they didn't get the therapy at that time.
Now, in January 23rd, 2019, they also went back to Dr. Reichenbacher, correct?
Yes.
And the chief complaint that his parents brought was that he has some anger, correct?
Yes.
And the mom reported some improvements in his ability to not get angry or apologize and later on, correct?
Yes.
And the child got tearful when his mom was talking about him, correct?
That's what the report said, yes.
And they reported that he had not been seeing a therapist at that point. And the doctor, again, recommended that they should do medication and meet with a therapist, correct?
Correct.
At no point did Dr. Reichenbacher recommend confinement
Never.
to the parents. And at no point did the parents report that there was issues with the child hurting animals, correct?
To that doctor?
To Dr. Reichenbacher.
Right, to that
No.
doctor, no.
And I think that you mentioned that that was something that may have existed in this case, but isn't it true that the only issue that he ever had with an animal is when he overfed a dog?
No, he had been riding a bicycle and was riding the bicycle into the dog.
Okay, so he hit the dog with a bicycle.
Yes.
And you know that in 2022, in January, at the time that we're talking about, from reviewing the videos, that there were times where the child is allowed to be alone with the dog?
No, I didn't.
You didn't see that? There's times
I did
maybe-
see him out with the dog, but he wasn't, the family was around.
Okay. Did you see any of the videos where he's alone with one of the dogs in the room, in his structure in the garage, locked in the room, and the dog's in there?
Oh, I didn't recall that.
No. Okay. And there's other times that family had multiple pets where he's allowed to be around with the pets?
Yes,
Correct?
I mean, I definitely saw him with the family with the pets.
Now, going back to reactive attachment disorder, social and the diagnostic criteria, social neglect is a necessary condition, meaning that there has to be a time in the early childhood where their child was subject to extreme neglect, correct?
That's right.
But it doesn't necessarily mean that just because that occurred that a child is going to have reactive attachment disorder, correct?
That's right.
And when a person has reactive attachment disorder, there's actually two types, correct?
Yes, it's been divided into two types.
There's one where the child is overly affectionate, almost indiscriminate with their affections towards adults.
Yes.
That does not seem to be the case here. There's no indication of that.
No.
So that's not what we're talking about here.
Correct.
The other one is when the child has difficulty forming attachment, correct?
Yes.
And there's nothing in the criteria or what we're looking at in diagnosing it that has anything to do with violence.
No, it's only if the child will refuse to be comforted by a caretaker or will not go to the caretaker to be comforted. So it's very specific.
Okay, so you saw a lot of times see a child that appears withdrawn or unable to be comforted by an adult.
They're not necessarily withdrawn, but they're unable to be comforted. So they're having intense temper outbursts, and the parent goes to comfort them, and they don't want that. It makes it worse, actually. Or the child hurts himself or is out of control emotionally and won't go to that parent for soothing. So it's a very disturbed way of attaching.
Right, but there's nothing in the criteria that says that the child has to react towards themselves or others in a way that involves violence.
No, I mean, not necessarily. But when you look at it and when you look at reactive attachment disorder as it is studied, these are the behaviors that are seen in the studies when people are diagnosed with this.
Now, when people are diagnosed, the DSM tells us to, and I think you've already agreed, that after 5, it should be done with extreme caution. And that's in part because it is unclear if reactive attachment disorder even occurs after the age of 5, correct?
Sure. So what happens is many people, some people are in the camp that, you know, you can have persistent reactive attachment disorder that goes through middle childhood, through adolescence, into adulthood. Some people are of the camp that, hey, it's reactive attachment disorder, but really what's underlying it is that complex PTSD, and that's why we see it continue throughout the lifespan. So it really just depends on what camp you're in. There's a little bit of research for both.
Now, according to the DSM, the reactive attachment disorder is incredibly rare, correct?
Yes, it's not something that you would see often in your practice.
And you're familiar, and it's something that is considered that has a high risk of misdiagnoses, correct?
I think that it did back in the day when people were first hearing about it and calling everything that a child did rad, you know, everything was rad. I think now clinicians are way more cautious about diagnosing, but when you see somebody like Ronan that has that really severe neglect, malnutrition, scabies, I don't think that it's a leap. I think it's you know, it makes sense and based on his behavior.
Well, you're a member of the American Professional Society on the Abuse of Children, correct?
I am a member, yes.
And that is, it goes by the acronym ABSAC.
That's right.
And as a member, you stay up to date on the professional recommendations and also ABSAC's positions on the latest research and community standards for the treatment and for child abuse, correct?
Correct.
And ABSAC, the task force, issued a report on attachment disorders and attachment problems, correct?
They did.
Reactive attachment disorder is actually disproportionately high number of children misdiagnosed with those, especially those who have only a mild or moderate symptoms, correct?
Yes.
And the report points out that, and I think you already discussed, that there is incredibly abusive ways in which sometimes reactive attachment disorder gets treated.
Yes. Horrible.
That includes extreme control over every action that the child has, correct? In extreme circumstances.
Yes, it's parents that are desperate parents trying to control these behaviors, and they're controlling these behaviors in ways that are detrimental to the child.
That are harmful.
Yes.
And the report points out that one of the key things for treating reactive attachment disorder, or ways in which it is recommended in general to be treated, is it focuses on actually the actions of the parent as opposed to the child.
That's correct.
The most effective therapies actually don't rely upon the child, correct?
It's mostly teaching the parent how to parent that type of child, because parents think, especially foster parents or adoptive parents, think that love is enough, and if they just lavish this child with love, this child's going to get better. And it's very frustrating for that parent when they're trying to do all they can and the child is not changing or getting worse.
Now, I want to talk about hoarding food. Hoarding, stealing food is something that you see commonly in children that have a history of deprivation or come from deprived or neglected backgrounds, correct?
That's right.
And the way in which to deal with that behavior is not to limit access to the food.
It depends. Now, there actually are many foster parents that put locks on their refrigerator because during the night the kids will get up and they'll eat every single thing. So I think that there is a way to therapeutically put some limits, but to take food away from child or not let them have food, that's totally inappropriate.
Now, let's talk about PTSD. You said that it's your opinion that there is complex PTSD here that occurred in the early childhood, correct?
Yes.
The DSM also sets criteria for post-traumatic stress disorder, correct?
It does.
And it has a separate criteria for children that are over 6 and children that are under 6, correct?
Yes.
And the first thing in order to be diagnosed with PTSD is you have to directly experience a traumatic event, correct?
That's right.
And it gives examples of traumatic events, but there are things like actual threat of physical violence, death, bodily harm, correct?
Sure.
It doesn't talk about lack of food or being in an orphanage. There has to be an actual physical violence experienced by the child, correct?
No, I totally disagree with that. I don't think that the DSM-5 could list all the different types of trauma. And I think severe neglect absolutely would be part of severe trauma for children. Also, you say bodily injury. Starving a child and giving them sugar water is bodily injury. So yes, these children are experiencing trauma and they're experiencing bodily injury. They're just not old enough to talk about it.
So the DSM says exposure to actual or threatened death, serious injury, or sexual violence in one or more of the following ways. Directly experiencing the traumatic events, right?
Correct.
Witnessing in person the events as it occurred to others, especially primary caregivers, correct? Or learning that the traumatic events occurred to a parent or caregiver, correct? Those are the 3 things that they have to directly experience, correct?
It could be either one of those.
It could be any of those 3, and the alternative.
He had directly experienced it.
Now, you also said that it can occur in infanthood, but the DSM says that PTSD can occur beginning only after the first year of life, correct?
You would wait till they were like 9 months old before you would diagnose that. But again, it would be diagnosed not through the DSM if they are a young child. It would be diagnosed through the diagnostic classification 0 through 3, which is a whole different book.
Okay. But the DSM, right, the Diagnostic and Statistical Manual of Mental Disorders, says that it's occurring after the first year of life, correct?
Right.
For PTSD.
I mean, that's what they say. And you're not going to necessarily diagnose PTSD until a child is a little bit older, because you would have to see emotional lability. You would have to see that child having difficulty sleeping. There'd have to be some symptoms that you're seeing that wouldn't be attributable to that child just being a newborn.
So in complex PTSD, you see interpersonal trauma, and these traumas have caused them to experience fear, horror, anxiety, to the point where they now have developed a disorder, correct? That's how you would describe it.
Yes.
And symptoms that you may see in a child that has, or a person that has PTSD are emotional reactivity, correct? Emotional numbing, correct?
Yes.
Lack of trust
Yes.
and avoidance, correct?
Correct.
And there are treatments for PTSD even for young children.
There are.
And there is trauma-focused cognitive behavioral therapy, correct?
You can start that as early as age 3.
Some people do EMDR with children.
They do. Yes.
And the focus is not on the behaviors when treating PTSD, but what's underlying those behaviors in terms of abuse and neglect, correct?
Exactly.
It would not be appropriate to confine a child to a room with PTSD as was done in this case, correct?
Correct.
That would never be appropriate, correct?
Correct.
Reacting to a child who has complex PTSD or an attachment disorder with things like anger and threats is not productive or helpful to a child with those conditions, correct?
Right.
And those reactions create a psychological harm to the child, correct?
Yes, and it can exacerbate problems that were already there, for sure.
Adding to the existing harm.
Yes.
Making it worse. I see you nodding. We just have to say
Yes.
out loud, yes. So PTSD can be worsened by ongoing abuse and neglect, correct?
Yes.
In fact, you would agree that there would have been damage done to the victim's neuropsychological health from the defendant's actions in this case, correct?
Yes, most likely.
It's your opinion that the way that his parents handled the symptoms from PTSD exacerbated it, correct?
I do believe that.
And this is not a way that a child with early childhood neglect should be parented, correct?
That's right.
Not only was it harmful, but none of the ways in which they addressed him or he was treated would be useful as constructive punishment, correct?
Right. No.
Now, I think that you also said when we spoke previously that there were some indicators that the child was experiencing some symptoms of depression prior to the removal from his parents.
Sustained. Next question.
Let's talk about abuse and neglect generally. Over the course of your career, have you come across cases where there was ongoing abuse and neglect, but the abuse and neglect wasn't apparent to others who interacted with the family?
Say that last part again, I'm sorry.
Have you come across cases of abuse and neglect, ongoing abuse and neglect, where that ongoing abuse and neglect wasn't apparent to people that interacted with the family?
Oh, wasn't apparent. Yes.
Sustained.
Your Honor,
You want to approach? You can.
Cases involving abuse and neglect, can the child who is exposed to ongoing abuse grow a tolerance for the environment that they're in?
Overruled.
Yes.
And so even in cases where that environment that they're subjected to is abusive or neglectful.
Sure. Yeah.
So there can be a normalization of that type of treatment for the child.
Yes.
Now, I want to talk for a second. Just make sure I didn't miss anything. About the interventions that occurred. You talked a little bit about that. Defendant provided you with a attempt or a list of their attempted interventions, correct?
They did.
Based on the information available to you, the last time that the victim in this case was seen by a psychiatrist or a mental health professional to address any behavioral issues was mid-2019, correct?
That is true, although I did, after that, after our deposition, I did receive information that they had reached out to I believe, a medical doctor, a primary care physician, and were asking for referrals for a psychiatrist, but they were in the process of getting the referral from their doctor before he could go to see one.
Right,
And
so-
that was more recent.
So the last time, though, that he was ever seen, as far as you're aware, by a psychiatrist or a psychologist was in mid-2019.
Yes.
And recently there might have been maybe we should talk to someone again, correct?
Yes, that's when they moved here.
Right, after they had already been confining their child for approximately 3 years, correct?
Yes.
They also provided you that they sent one email in December of 2022, or December of 2021, excuse me, that they reached out about a meeting with a transcendental meditation person.
Correct. They were trying to get Ronan into transcendental meditation to help
Right.
calm his behaviors.
They sent one email in December of 2021, correct? Based
Correct.
on the information that you had.
Correct.
Transcendental meditation's not a medical doctor, a psychiatrist,
No.
a psychologist, a licensed clinical social worker.
I'm not sure who can do it, but I don't believe it is in the mental health field.
And based on the information provided to you, there were no counselors after that date either. He wasn't continuing to see a therapist or a mental health counselor or a licensed clinical social worker after mid-2019, correct?
Correct.
And based on the information provided to you, that he started being held in the structure in early 2019, correct?
Yes.
And there also was no indication that an individualized education plan was ever sought at his school.
Right. I believe he was in private schools, no? But
So-
no, they did not.
Yeah, so there was no individual education plan.
Right.
And then when he came to Independence Middle in Jupiter, when they moved in December of 2021, January of 2022, there was no IEP sought, correct?
Right. I don't think that, I mean, they had just gotten there, and I believe it was over Christmas time, so I don't know that they would have been getting it that quickly, but no, I didn't see evidence of it being sought.
Did you see that they reported no behavioral problems when they enrolled him in to Independence Middle School in Jupiter?
I don't recall that, but I'll take your word for it.
Now, I want to talk about the impacts this type of treatment would have on a child. I think you've already said that it would exacerbate any pre-existing problems that the child may have, correct?
What would, I'm sorry.
The type of treatment, the way that he was kept and confined, correct?
Oh, yes.
Would it also, and isn't it true that it's your opinion that it will also make the child feel rejected, correct?
Yes, it could.
It make the child feel like they're not good enough, correct?
Yes, it could.
And make the child feel like they are inherently bad, correct?
Yes, it could.
It can lead the child to maneuver or manipulate through a situation to avoid that isolation.
Yes, it could.
It can lead to depression, correct?
Yes,
It can lead to suicidal ideation, correct?
it could.
When a punishment is chronic, meaning that it happens on an ongoing basis, you will see a bigger impact too, correct?
For sure.
And as to the victim in this case specifically, you think that what was going on with him, the issues that he was having prior, was really exacerbated by how his parents acted towards them, correct?
Yes, that's my belief.
There is a psychological impact, a negative one, when punishment is humiliating and isolating, correct?
Yes.
Now, as to the appropriateness of the punishment, it's your opinion that you don't think anything that they did or attempted to do that they did would help him be better, correct?
Sustained.
Isn't it true that it is not appropriate to punish bad behavior by placing a child in a situation where they don't have access to an ordinary bathroom?
Yes.
It's your opinion that should never have been done in this case, correct?
Yes.
That type of treatment is also humiliating, correct?
Yes.
The same is true for locking him from the outside. That is something that should never have been done, correct?
I agree.
That's also true for the inability to control the lights. That is inappropriate, correct?
Correct.
Inappropriate. That is going to have a negative impact on a child if it happens over a longer period of time, correct?
Yes.
Having a child sit in the dark in a locked room for long periods of time is not an acceptable form of punishment.
Sustained.
It is the type of thing that would cause harm, correct? That wasn't.
Sustained.
At no point is there any indication that these parents were advised to engage in this type of behavior, correct?
I didn't see any professional telling them to do that.
And that's because it would be something that would not be recommended by someone within the mainstream psychological and psychiatric community.
Yes, I'm glad you said mainstream, because absolutely there are many professionals that believe in a very militaristic type of parenting, authoritative type of parenting, strip everything out but their mattress, take their door off the hinges. There are professionals and paraprofessionals that do believe this is a way to parent, but people that are mainstream and that really know the research would never have suggested that.
Right. And there's no indication that even these non-mainstream people are involved here and said that you should do this, correct?
Right. I would not know that. Right.
The only advice that we know about is medication and therapy, correct?
That's correct.
That's all the questions I have.
All right, redirect, Ms. Murad.
Dr. Rappa, the state spent some time in their cross-examination sort of challenging the diagnosis of attachment disorder. So I want to talk about that, okay?
Okay.
Is your opinion solely based on the diagnoses that previous providers have made?
No.
What else is it based on?
I mean, that does help to know that previous providers had seen the same thing. But it has to be on behaviors, and it has to be on early childhood experiences, especially as it pertains to children, you know, from birth to age 3.
And in the record, did you see those patterns of behavior that led you to come to your opinion about the attachment disorder?
I did. I saw the severe neglect. I saw the scabies. I saw the malnourishment. And then I saw the behaviors. Or not saw, I saw in the records. The behaviors.
And you reviewed Wade Myers' trial testimony. Did the state's own expert, in fact, testify that Ronan likely has reactive attachment disorder from early childhood neglect in his own testimony to this jury?
Objection, Your Honor.
Sustained.
In reviewing Wade Myers' testimony, is it consistent with your opinion on attachment disorder?
Yes.
The state asked you about the deposition that you saw of Ronan and his sort of affect and behaviors. And the state mentioned that, you know, it's long, he's a kid. Is that what you made of it, or his affect, that it was just because he was a kid and it was a long deposition, or were there actual things about his affect that were concerning to you in coming to your opinion?
There were things in his affect that were concerning to me that went on my radar as I was watching.
Could you take us through those?
Sustained. You want to approach on that, Ms. Murad? Because I think she testified to that in her direct.
I think she did as well, Judge. That's fine.
Sustained.
And so you
Objection
maintain the same,
sustained.
you maintain the same opinion you had in direct examination, correct?
Yes.
The state mentioned, it sounds a little Sicilian retrospect, but something like transcendental meditation. Did the Ferriters sort of try both medical and non-medical options over time?
Objection, hearsay.
Overruled. You can answer.
Yes, they did. They tried many different things. They tried putting him into like karate, and they tried chess club, and then they tried to burn his energy off with crack.
Chess club.
They did
Let me
try.
stop you. Are you testifying from your review of the documents that you reviewed as part of your opinion? Or are you testifying from conversations with somebody?
No, sir, I didn't have conversations.
So,
these
all
are
right, so I'm going to allow the answer. You can continue.
Thank you. Go ahead.
They also tried putting him into a meditation class so that he could learn to control his behavior. So I think they tried, and they tried nutrition, they tried taking away gluten, they tried taking away sugar. I mean, there was a bunch of different things that they did try that were outside of the mental health world.
Based on your experience sort of working with families, and particularly children with a history of trauma and their parents, I mean, is that, I guess, What do you make of that? Was that neglectful of them and not pursuing every medical option, or is it something that parents do in trying to?
Sustained.
The state mentioned the transcendental meditation, and you mentioned several other efforts that the Ferriters made. Those are obviously not medical efforts, correct?
Correct.
Does that change your opinion as to whether or not they engaged in malicious punishment?
No, does not change my opinion.
Why not?
I think that they were trying the best that they knew, and what they.
Sustained.
Without what you think, so the state's expert testified that based on the Ferriter's conduct, he believed that there was malicious punishment, correct?
Finish the question. You hadn't finished. I hadn't gotten to the. You hadn't gotten to the question. So finish your question.
Is there conduct that you have reviewed that shows to the contrary?
Yes.
Okay. And can you take us through how you've come to that opinion?
Yes. There's conduct by Tim that the tone is terrible. The tone is awful. And how he's talking to the child with that tone is bad. But what he is saying to the child isn't horrible. He's saying, I want you to get better. I want you to make right choices.
Sustained.
Your Honor, there's already in evidence. The jury watched the Ring videos.
Response. I remember one of the videos where that was said. So as to that particular comment, I'm going to allow it. You can continue answering him. Objection overruled.
Thank you. Go ahead, Dr. Rappa.
He was saying, I want better for you. People are going to not want to be your friend or be close to you if you continue to act this way. I want things different for you. And while his tone was bad, what was coming out of his mouth was not bad if he had been using a different tone.
The state talked about let me start with this. The state talked about the effect that the Ferriters' actions had. You're not disputing that what they did was wrong, right?
No.
Okay. So let's sort of take it back to that 2018 period. The state mentioned a number of different school emails or referrals that Ronan had, sort of acts that Ronan had between 2018 and 2019. Is that fair to say?
Yes.
In cross-examination. They talked about stealing sprinkles, some fights that happened. Is that correct?
Yes.
First off, how does a psychologist separate what is regular childhood behavior from what is so concerning that it amounts to a disorder?
I think that what we look at is persistence. Is this happening over and over and over? Is it a pattern of behavior? And is this behavior not going away, even though school might be punishing or the parents might be punishing or giving consequences? The behavior continues to persist.
Do you see that as it relates to Ronan in the records in this case?
Yes.
Do you see that in this case, in the records as it relates to Ronan, even prior to May of 2018 when Tracy got pregnant?
I'm going to overrule it because the answer's already been made of record, so it's really cumulative at this point.
You can answer this question, and then I'll move on, Judge.
So yes.
Okay. The state mentioned that in your work, this is the first case that you've testified regarding malicious or allegations of bizarre punishment. Is that correct?
Yes.
Have you testified about early childhood trauma?
Yes.
How often?
Oh, my word.
Hundreds of thousands.
A high number. I mean, I've been doing this for 20-something years, and, I do trauma work, so a high number.
And when you are sort of hired, do you work for both the defense and the state?
I do.
If you had to put a percentage on it, how often are you working for the defense versus the state?
Right now, probably about 50-50.
And is that locally in South Florida and nationally?
It's throughout Florida.
And have you, in fact, been hired by this state attorney's office on a number of cases as it relates to childhood trauma?
Childhood trauma? I don't remember in specific childhood trauma, but I have been hired and enjoy working with them.
One moment, Your Honor.
Okay, thank you, Ms. Murad. All right, ma'am, you just remain where you are. Ladies and gentlemen, it's about 12:20. We're going to go ahead and break for lunch for you folks. We'll start back at 1:30, so be outside at the elevators at 1:25 to meet with Mark, and he'll bring you to the jury room. Remember, you haven't heard it for 3 days, but I'll remind you, don't discuss the case with each other or with anyone else, do any kind of research at this point. Other than that, enjoy your lunch.
We'll be back after lunch. See you guys in about an hour.
All right, everyone may be seated. Let me have counsel approach you. Ma'am, can you come down here in front of the bench, please?
Sorry, I don't want to miss this, so we'll keep going.
Okay, so you guys can go back to your table. Before I let the attorneys go for lunch, go to the mic. Yeah. So the question I have is for the afternoon session, you have about 3 hours of
My hope is to play the videos that I intend to play. I provided the state with a actual copy of the video, and just so the court knows, I understand the state's entitled to time to review it. I'm not, we'll deal with any objections. These are the videos that were in the 21,000, so these are not,
Okay.
these were in the state's possession.
Well, the 21,000 is already in evidence, right? I mean,
No.
What is in evidence? I thought it
Only
was,
of the room. The state admitted videos only of inside the room, and then
but then we had a subset of that as well that was played, right?
Correct. So what was played in the room, I would have a problem with my ability with what they're entering in. On Sunday, they provided me a list of 3,000 videos, it's 50 hours.
But what's your legal objection? Because
So
if,
I've already looked through some of them are self-serving hearsay, they're saying things to the child victim in there. Some of them they keep out the part where they're like, there's a rule of completeness problem, in the sense that there's an example in the 3,000 videos, there's a line of videos where the child is out in the living room playing with them, and then they delete the part where Miss Ferriter makes him go to his room and the other kids continue to play. So there's that problem, and that's why like the child looking at it for a couple hours. There's one where it's frame, like that would be improper character evidence and inadmissible. And so I tried to look through the 3,000 videos that they sent me. They said that they intended to make 50 hours of video. And so now, yesterday evening at 9:30 at night, they now are saying they want 14 hours. And so it has to be manageable for me to look at to see if there's discussion. Beyond that, the exhibit that they have provided does not indicate times or what file they're looking at. It's just a montage of videos without context, which I think is problematic and misleading to the jury. When the state admitted it, we admitted the actual videos with the times. And our composite exhibit has that as well. So I think it's problematic. I can't even check what they put in to make sure it's the correct order, the correct day, and the correct time, because they haven't given me the file names or in what order.
So, Judge, I would like to respond to this because I think there's sort of a fundamental issue. Obviously, there are a lot of videos in this case, and each side is entitled to review anything before it goes in front of a jury. But this idea, I mean, that has unfortunately been the practice on both sides as it relates to the videos. I received their list of their 8-hour montage 7:30 the night before. And when I said, Judge, I think we have something here that we may not have been disclosed, the court said, figure it out or don't, but bring it to me.
same thing I'm going to say now, figure it out. Here's what I'm going to do. You're going to play the videos, you make your contemporaneous objections at the time it's being played. You stand up, you object, and if I think there's inadmissible hearsay coming in, I'm going to order stop play immediately, hear the objection, and if I rule, if I sustain the objection, then you'll have to move on to the next video segment, or at least mute out the objectionable hearsay.
May I address?
Let me finish. I'm not so terribly moved by the lack of specific date and time of the videos, if the understanding is that these were all videos during the relevant time period from December 28th or so to January 28th. I mean, that may be, that's something that might go to the weight, but I don't think it goes necessarily to the admissibility.
But they lay a foundation for, like, they're making assertions of the date that these are on.
But are these already in evidence?
No.
No, they have to be, you can't play them without them having been in.
The state advised me that they would not be objecting to the date and time. They're done by date, and then they're done in chronological order because the epoch time, so I called Lowe this morning, I confirmed with Ms. Coakley in front of Agent Lowe and Mr. Wahed, and I said, hey, he's testifying, you're not contesting this, right? As to the foundation of just the dates and the times, and she said, no, I'm not contesting that. I even emailed her over the weekend because there's some videos, as Agent Lowe testified, that aren't in the epoch time, they're in the 7505, how those times are determined. So I can call him back, but I don't know that that's reasonable because also there's zero dispute that these are from the time frame charged in the information because these are the only videos that exist that the state's had since February 3rd of 2022.
All right, so I'm not, obviously not going to permit the jury to see anything that's not in evidence. So we have to cross the threshold first of, is this going to be admitted into evidence? So is Ms. Murad correct that you told her that there was not going to be any authenticity type objection?
I'm not an unreasonable person, Your Honor. I am not. I agree that the videos and the date and times, what she has provided me is a 14-hour video that does not have, I can't confirm anything. I can't say that this is from that day. If she gives me the file names or the video included the file names so I can spot check them, I would stipulate to the date and time. What I have been provided is an hours-long montage of videos without any signposts as to what they are. That's my problem.
So the videos have the date, and then you see the videos from so it goes December 29th, video.
Where's the date? In the file name or in the video itself?
It's in the video itself, just like the state did.
And is that an accurate rendition of the,
Yes,
the
Judge.
date and time?
There's no times. There's no times.
Just the date?
There's just the date, and then there's hours of video without any times, and then there's another date. And so that is my issue, is that I can't check it. I can't tell what was missed out because I haven't been provided that information to check.
So we did provide it's about 889 videos, which I know sounds like a ton, but again,
Let me ask you this. When you folks estimated this trial was originally going to take 5 days, and now we are on day 7 and looking like day 8 and possibly day 9, I mean, I put a lot of credence in attorneys' estimates of how long it takes to try a case, but this one seems like another universe in terms of the reality of where we actually are versus what was represented to the court as the amount of judicial time that was going to be necessary to be set aside. I guess what I'm getting at, has all this changed on the ground in terms of how much of this video is being presented? Or were you aware of this from the very beginning, that you intended to have 14 hours of video that you wanted to play to the jury?
I actually didn't. I didn't know. I knew the state was going to play some videos from inside the room. I didn't know they would amount to approximately 8 hours. Also, their witness was deposed pretty close in time to the trial and made the claim that this was solitary confinement. So
Right,
I didn't expect it to be this late.
Let me move on. Unless you're seriously contesting, Ms. Coakley, that you didn't advise the defense that, let me state it another way. If I accept Ms. Murad's representation that she was not aware there was going to be any authenticity objection, I'm going to allow the playing of the videos without prejudice to the other objections. But as long as there's a date on the video that shows it was during the relevant period, I'm not going to deny it coming into evidence as a result of it having a timestamp. Again, I think that goes to the weight as opposed to the admissibility. So I will allow that to be played, but I'm also going to require, Ms. Murad, that as you play these videos, you let the state know which video file you're playing so they can pull it up on their systems and do whatever they have to do. You need to move these documents in evidence, and so when I receive them in evidence, it's going to be a limited admission because if there are specific objections to the content, like self-serving hearsay or some other basis for an objection, and if I sustain that objection, that's going to have to be redacted from the evidentiary portion that the jury would be entitled to review. So if you want to comment on what I've said, if the defense was led to believe there was going to be no authenticity objection, I'm inclined to let them pursue the way they want to and not get so hung up on the lack of a timestamp where there is a date stamp on the video, and where there's no reasonable dispute that these were part of the video montage of what had occurred in his home during the relevant time.
Your Honor, I told them that I would agree to the date and time. They have not provided me the date and time that they're offering to admit, and so then there's no way for the jury to have contact. So that is the state's problem.
Well, she's saying the date is going to be on the video.
It's going to be on there, and then we have no idea what time, if they're out of order or anything, because it's not contained. The way that the state did it is to provide what file name was for every single video that was provided.
So,
It's 14 hours, and there's no way for me to check what was left out or not left out, because they gave it to me this morning. And so, there also has to be like about what is cumulative evidence and what is like a reasonable amount of evidence for the jury to get. Just give them 14 hours without contact.
I don't disagree with that, but the state did play a lot of the videos, and I certainly am not going to limit in any real way what the defense wants to show is what they believe is the rest of the story with respect to the videos. They're entitled to do that. But in the same vein, Ms. Murad, the state was very meticulous in telling you the date and the time, and even having the UTC or UPC explained as to how it translates into local time. Are you unable to tell them what the date and time of each video that's playing is?
First off, when the state provided it to us, it was all, I mean, that entire list that they.
I'm growing weary of this argument. Answer my question. Are you able to provide them with the date and time of each video that you're playing?
Not in the next hour and a half, but I can get pretty close. And we do have a list that we provided them of the videos used. So I can get started on it, and I can certainly provide that.
I mean, don't you think that's something that they would have reasonably been entitled to know the date and the time
So
of the video you're
actual
playing?
file name is indicative of the date and time.
You have the file name then of each video you're playing?
Yes, and we provided that to
All right.
them. They initially
Okay.
got something bigger on accident, and then I corrected it.
So here's what you're going to do then. Prior to each playing of the video, you're going to provide them the file name of the video being played.
Okay.
And then they can track it through that. Okay, everybody clear on that?
And I can announce that on the record as it goes through.
You announce it on the record, but I'm going to explain to the jury what's going on with the presentation is after you move the videos into evidence.
Okay.
And my general overruling of the authenticity objection is without prejudice to, again, assert any other substantive objection by the state, which you'll have to do in real time as the video is being played. I know of no other way to do it efficiently than to do it while it's being played. Let me hear the objection. And how are you going to handle the playback on this, Ms. Moran?
What do you mean? So we can use the toggle and put it on.
So somebody's going to have to be there on the button that when the objection is made, you stop it until I hear the objection. Okay?
I'll be mindful of that.
So how are you going to know which one you're playing now? It's 14 hours.
So we have it on a software, so I should be able, through the software, to identify. I mean, it's going to take me a second, but that is what I will do during the lunch hour. And if there are issues, I will let Ms. Coakley know, but I don't anticipate there will.
So back to the larger question here. I keep hearing 14 hours of.
I'm not playing 14 hours.
So how much are you playing?
Just for the afternoon, Judge. I need to speak with my client about whether or not he wishes to testify. We'll do that conversation during lunch. So it's very likely defense may rest today.
Okay. All right. So that's how we're going to proceed. Ms. Murad, you're clear on the process, and Ms. Coakley, are you also clear on the process? I know you may not agree with the process that I'm implemented, but it's what I'm going to order in any event. I just want to make sure you're clear on it at this point.
Yeah, I mean, so the problem is that there's going to be things going into evidence that are not going to be played.
Well, that happened. I mean, that doesn't concern me because that happens all the time in criminal trials.
Sure, but I'm not going to have an opportunity to review them before they're put into evidence, and presumably the jury could see that.
Well, if all you're making is an authenticity objection,
So, like, as to hearsay, as to,
to the substantive objections.
right, like that, like, I understand.
All right, so let me, both of you have, I won't say both, but a significant evidentiary issue has been created for the court in terms of how to manage this. Ms. Coakley is absolutely right that before she agrees to a carte blanche omnibus admission of all these videos into evidence, normally the practice is that the other side would have already reviewed what's being submitted into evidence, and there would be appropriate redactions in advance of the day of trial having it played. So how do you address that, Ms. Murad? Because it's a real logistical issue that's been created, and Ms. Coakley's absolutely right. If you're only going to play 3 hours, then that's what should come into evidence. If there's more, then I have to give her time to review and see if there are any other objections.
So the jury's probably not going to go out with any of this until tomorrow after 5. Let's say we rest today, closings are 12 to 5, we have to do jury instructions. So then we could not admit the formal exhibit until the state has had an opportunity to review it. And I know that this isn't really a defense judge, it's more just my practice. This was the exact same situation we were in with me, and I trust the state. And
The state may not trust you, though.
That's a
I mean, and I say time and
no,
again,
that's all right, I understand.
just because one side doesn't object doesn't make it right when the other side, or wrong when the other side objects. So here's how I'm going to handle it. I'm only going to admit into evidence what is actually going to be played to the jury this afternoon, because that way I will deal with any real-time contemporaneous objections to the substance of what is said. As for the remaining part of the videos, I'm going to instruct both sides to do what you have to do to review the remaining part that's not played to the jury, and if there are additional instructions or objections that are made, then I'm going to have to rule on them and make sure that they're redacted before that remainder that's not played to the jury today is made available to them once they go into the jury room for deliberation. So that's the best I can do in terms of handling what normally is resolved way before we ever get to the day of reckoning like we are here. And so that means more work for you, Ms. Coakley, but I'm giving you the opportunity to review what's not being played to the jury for your purpose of asserting any additional objections. And the only objection that I'm kind of moving past is the authenticity objection, and I think everybody understands the reason for that. Okay, so last thing before I let you go is jury instructions. We're going to have a conference today, because if there's a reasonable chance the defense is going to rest today, then we would start tomorrow with closing arguments and have to have the jury instructions ready prior to that time. So think about that over lunch. I'll see everybody back here at 1:30 sharp.